Hi, this is an interesting judgment of Bombay High Court. The relevant act is Micro, Small and Medium Enterprises Development Act. Sonali Power Equipment versus Chairman, Maharashtra State Electricity Board. Nearly 5 to 6 questions were before the Bombay High Court. So, some interesting questions. The first question was whether, in view of the MSMED Act, the jurisdiction of civil court is taken away. That was the first question before the Bombay High Court. The Bombay High Court held jurisdiction of civil court under section 9 of CPC is all pervading unless it is shown to be barred by an express provision contained in the Act or is held to be impliedly barred. There is no express provision of booster of jurisdiction of civil courts under the MSMED Act. So merely because SPD mechanism is created under the MSMED Act, that by itself cannot be held to indicate the booster of jurisdiction of the civil court. That is what the Bombay High Court said. Bombay High Court said even civil court has got jurisdiction, not only the the Facilitation Council under the MSMED Act. The second question was whether section 21 of AMC Act has any relevance to section 18 of MSMED Act. So first we should know what is section 21 of Arbitration and Conciliation Act. That is, it states arbitral proceedings shall commence on the date on which the request for the dispute to be referred to arbitration is received by the respondent. Commencement of proceedings, when the proceedings will commence. Section 18 of the MSMED Act states, notwithstanding anything contained in any of the law for the time being in force, any party to a dispute may, with regard to any other amount due, make a reference to the Facilitation Council. So it is the date when it is referred to the Facilitation Council. The conciliation, the High Court held, the conciliation and arbitration under section 18 of MSMED Act are statutory upon a reference being received from a supplier. Section 21 of Arbitration Act has no relevance whatsoever. That is what the High Court says. Now the third question is an interesting question. Whether the peculiar provisions like thrice the bank rate of interest, interest compounded monthly, direction to mention principal, interest and amount unpaid in balance sheet by the buyer, step-by-step approach adopted in section 18 and overriding effect in section 24 of MSMED Act, whether they are all sufficient to exclude the applicability of the Limitation Act. So simply put, whether the Limitation Act will apply or not for the proceedings under the MSMED Act. The Bombay High Court held all these provisions indicate applicability of Limitation Act. Otherwise, what will happen? The supplier can make a claim before the council at any point in time, even decades later. Bombay High Court gives an example. Suppose somebody has got a claim in 2007. He will not make a claim. In 2023, he will make a claim. So, this means supplier can claim interest on the amount due, which on account of passage of time would have exponentially spiraled, making such recovery destructive to the business of the buyer. The buyer actually will have civil death. The provisions of section 22, which requires entries to be made in the books of accounts, it would be conclusive proof of the liability of the buyer and for speedy recovery of the amount. The only purpose is it is a conclusive proof. Once it is recorded in the books of accounts of the buyer, then there is no other evidence that is required to prove that I supplied the goods to him or services to him. The provision in fact supports the applicability of Limitation Act. The continuity of the cause of action cannot be indefinite. This is what the Bombay High Court said. Then the fourth question was whether the mention of unpaid amount in balance sheet of the buyer must include time barred claims also. So there is a mandate by the under the MSMED Act that whatever claims are there, it must be mentioned in the balance sheet. So even the time barred claim should be mentioned or not. Then the subsequent incidental question is, what is the intention of the legislature in mandating mention of unpaid amount or even time-barred recoveries separately? The Bombay High Court says, language of section 22 is open-ended. It does not provide for any other limit and would indicate the liability of the buyer, whose accounts are required to be audited, to make entries as indicated therein, without any time frame. But the same cannot be held to mean that it would be an indicator of even, stale, dead and time-barred claims being permitted. The concept of continuous cause of action cannot be stretched to an absurd period of time, where its enforcement would make it an engine of suppression and not of providing justice. The Bombay High Court says the intention of the legislature can never be presumed to create a provision which causes injustice or oppression. So, the very fact that you should mention the entries in the books of accounts or in the balance sheet, even of the time-barred claims, does not mean it will give you a fresh cause of action so that you can claim at any point in time. That is not the intention of the legislature. That is what the Bombay High Court says. Another question before the court was whether such a disclosure of unpaid principal amount or the compound interest quantum separately gives rise to the fresh or repeated annual causes of action for recovery of the principal and interest amount. So every time you are mentioning compounding interest is there, so somebody goes on adding it, whether it will give fresh cause of action. The High Court says the cause of action for approaching the council under section 18 starts on the expiry of 45 days from the date of supply of goods or services or from the deemed date of supply of goods or services. The liability of the supplier is thus immediate. The purpose and intent of the section 16 and charging of interest on compound basis with monthly rest appears to dissuade the buyer from making delayed payments. So they cannot make the delayed payment, the buyer. It is not to be used as a tool for oppression by the supplier by letting the time to lapse and inflating the claim by charging interest and then approach the facilitation council. In the view of the High Court, the law in fact compels availing of such remedy without any delay by the supplier. The charging of interest would not amount to a fresh cause of action at the end of every month on account of provision permitting charging of interest at monthly rest. Then it would be not time limit for a supplier to raise a claim for each month would give him a fresh cause of action, and any claim can be sought after decades later. So such an interpretation would clearly defeat the purpose and object of the MSMED Act. So whenever there is a claim, the supplier has to immediately approach the council within 45 days and then make a claim. He cannot just sleep for decades together and then he can make a fresh claim. That is not the object of the MSMED Act. Immediate payment to the micro and small and medium scale enterprises is the crux of the Act. That is what it says. The conclusion is, the sum and substance of the judgment is that the claims for monies unpaid for goods or services rendered have to be raised and filed within a reasonable period of time. It cannot be left to be agitated at the sweet will and choice of the supplier at any point of time in the future without any restriction of time. That is, Limitation Act will also apply. If the MSMED, that is the small scale industry person, has not filed his claim properly within the particular time, then naturally the Limitation Act will apply and the claim will be time barred. That is the sum and substance of this judgment. I think it's a full bench judgment, which is very, very interesting. Thank you for hearing this. So we will see many interesting judgments in the days to come. Thank you very much. Have a great day.